We are on the record. Welcome back to the next session of our hearing today. We're going to go maybe slightly out of order here because we have some things that are being continued. So let's move down to item 3, which is docket number 2023-022, cause number 471-03. In the matter of the request for agency action of Heavy Sweet Oil LLC and AC Oil LLC for an order establishing the Asphalt Ridge Enhanced Recovery Unit for the in situ production of heavy oil from sands within the Rimrock and Asphalt Ridge deposits. This matter has been continued to a special board meeting on June 12th, 2023 in this boardroom. And I believe it will not be recorded, is that right, or will it be recorded?
It will be recorded for a record, but it will not be live streamed.
Will not be live streamed, okay.
Oh, and it is at the DEQ building. They're doing some work on this auditorium, so we needed to find a new space.
Okay. So we will be at the DEQ room instead of this boardroom.
The building.
Right, the building.
Yes, that's right.
Do you have anything further?
No, I believe, well, Mr. McDonald is here representing one of the parties, but yes, that just matter has been continued, and so we'll see you on June 12th.
Any comments, Mr. McDonald? Okay. Okay, let's move on to item number 4, which is docket number 2023-023, cause number CO 250005-NOVCH 04182023-1. In the matter of Alton Coal Development LLC's petition for review petition for hearing of notice of violation CH 04182023-1 regarding disturbing land outside the permit area of the Coal Hollow Mine, Kane County, Utah. I understand this has been resolved but not yet signed. Ms. Harris?
Yes, thank you. The parties have reached a resolution on this matter. We are just waiting for one final action to be taken. So we're asking that it be continued until, I believe I put the August board hearing to make sure that that action takes place, and then we'll be filing a motion to dismiss that.
Do we still need to appoint a hearing examiner for that, even though it's been resolved?
No, that one will be resolved, and we won't need it to go to the hearing examiner.
Okay. Then moving on to docket 5, or number 5, docket number 2023-024, cause number CO 250005-COCH 04122023. In the matter of Alton Coal Development LLC's petition for review petition for hearing of cessation order CH 04122023 regarding pit D-1 of the Coal Hollow Mine, Kane County, Utah. Now I'm going to move on to number 5 because these have been consolidated or will be consolidated. So the next matter that will join that previous one is docket number 2023-031, cause number CO 250005-NOVCH 04182023-2-3 in the matter of Alton Coal Development LLC's petition for review petition for hearing of notices of violation CO 04182023-2 and CH 04182023-3 regarding pit D-1 of the Alton Hollow Mine, Kane County, Utah. Now, it's my understanding these have, you're preparing to consolidate them, but that also has not been finalized.
Yes, thank you. So Jim Allen, he represents Alton Coal. He is not able to be here today, so I'm speaking for all the parties today. We have reached an agreement that this should be delegated to a hearing examiner, and that they should all be heard together. And so I have a proposed order for your review that will consolidate those matters and appoint the hearing examiner and set a pre-hearing conference.
Do we need to discuss the hearing examiner today, or is that?
The parties have all agreed that Chris Hansen, who is most recently a chair member, would be a very good hearing examiner. And so as long as the board is okay with that appointment, and you have, I mean, I'm happy to answer any other questions, but we are all on board with that happening.
Does anyone on the board have any concerns or comments?
Chris needs something to do, doesn't he?
I think so. He's been off the board for a month now, so. Yeah, I think that would be fine with the board.
Okay, if that is acceptable, then I can drop these proposed orders. There is a order to continue for the prior matter, and then also the order appointing the hearing examiner. I will give those to board counsel, and if you have those signed by the end of the day, we'll be set to go.
Thank you.
Thank you.
Anything else?
Nothing else. Thank you.
All right. Now we're going to go back to item number 1 on the docket. This is docket number 2023-020, cause number 132-17. In the matter of the request for agency action of OVINTIV USA Inc. for an order pooling interests, including the compulsory pooling of the interests of certain non-consenting owners in the Ute Tribal 13-30, 3-3-30-29, 1H well, in the drilling unit established for the production of oil, gas, and associated hydrocarbons from the Lower Green River Formation. And we'd like to open it up to Mr. McDonald.
Yeah, appearances of counsel. Madam Chairman, Fred McDonald of counsel with Lear & Lear on behalf of petitioner OVINTIV USA Inc.
Madam Chair, Trevor Gruwell with the Utah Attorney General's Office on behalf of the Division of Oil, Gas, and Mining.
If I could ask the IT people to have the OVINTIV witnesses who are appearing virtually up on the screens. Members of the board with me today appearing virtually, thanks to the board's order on May 16th, allowing them to appear virtually, are Mr. Jordan Lair, who is the senior land negotiator. He's raised his hands. And Mr. Brent Allison, who is the reservoir development engineer for OVINTIV USA Inc. I would ask that they be sworn in at this time.
Gentlemen, please raise your right hand. Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Brent, if you could move your microphone closer to you so we can pick that up on audio better. Thank you. Members of the board, the resumes of both witnesses were submitted collectively as Exhibit A in this matter. If separately asked, each would verify the contents of their resumes are true and correct. Mr. Lair has been previously recognized as an expert in petroleum land management before the board on several occasions. Presuming the division has no objection and based on his resume, I would ask the board to again recognize him as an expert in that discipline for purposes of this hearing.
The division has no issue with him being recognized as an expert.
Thank you. He's accepted.
Thank you. Mr. Allison is appearing for the first time in front of the board, and therefore we will qualify him as an expert in petroleum engineering at the commencement of his testimony. I just want to also confirm that in accordance with previous practice of the board, I will be moving for admission of my exhibits at the end of our presentation in chief.
Thank you.
Also, I want to confirm that the board received the supplement to Exhibit Z, which is just the additional green cards for the certified mailings that were received after the exhibit filing date.
Yes.
All right, thank you. Also, just want to confirm, pursuant to the order that was granted last night, that you have the supplement to Exhibit B, which is the order in cause number 139-104.
Yes.
Thank you. Members of the board, this cause involves the compulsory pooling of the drilling unit established for Lower Green River-Wasatch production, comprised of the entirety of sections 29 and 30 of Township 3 South, Range 3 West in Duchesne County. The drilling unit was established by the board, entered on December 14th, 2021, in cause number 130-10. A true and correct copy of the 139-10 order was submitted as part of Exhibit B, Pursuant to an order entered in 2012, which was the 139-90 order, Newfield Production Company, which was OVINTIV's predecessor, drilled and OVINTIV now operates a short lateral horizontal well located in Section 29. Production from that well has been allocated on a sectional drilling unit basis pursuant to the 139-90 order. BSNR Raptor Limited Partnership went non-consent in that well, and its interest was compulsory pooled by the board's order entered in cause number 139-104 with a 300% risk assessment award. A copy of the 139-104 order was filed as a supplement to Exhibit B. However, BSNR subsequently assigned its interest, and its successors leased their interest to OVINTIV. The 130-10 order expressly provides that production allocation from any existing well converts to the two-sectional drilling unit basis, effective as of the first day of the month following the first production of the first long lateral horizontal well drilled. Furthermore, OVINTIV agreed to waive any further recoupment owed as of that conversion date. In accordance with the 130-10 order and APDs approved by the Division and the Bureau of Indian Affairs, OVINTIV drilled the Ute Tribal 1H well, a long lateral well. Its date of first production was October 7, 2022, resulting in the conversion of the production allocation from the existing well to the two-sectional drilling unit basis on November 1, 2022. Although the request filed in this matter does not specifically request the vacating of the 139-104 order insofar as it pertains to Section 29 due to the circumstances I outlined above, the vacating of the order is merely an administrative necessity to remove it from the board's and the division's records and constitutes such other and further relief as may be just and equitable under the circumstances, as was expressly requested in the request for agency action. OVINTIV, therefore, is making a motion today to amend the request for agency action and specifically request the board vacate the 139-104 order insofar as it pertains to the Section 29 lands to eliminate any questions over its continued validity. I'll make sure that the board is okay with that.
Yes, board
Thank
is
you.
okay.
As identified in the request for agency action, and as Mr. Lear will testify, there are several parties who were provided and received the requisite notice of opportunity to participate in the Ute Tribal 1H well who have failed to timely respond or otherwise tendered their respective share of cost for the well as required under the applicable regulations. As such, OVINTIV seeks to compulsory pool their interest and have them declared as non-consenting owners in the Ute Tribal 1H well. The notices provided were identical in form to those that the board ruled in March as being legally sufficient under the current applicable regulations. However, recognizing the board's preference as expressed in that March hearing, OVINTIV will prospectively include in such notices the party's specific interest in the drilling unit and the specific owner's estimated costs reflected in the AFE. Two of the parties named in the request for agency action, Covey Minerals, Inc., and Amy Vaught Earls, as personal representative of the estate of George G. Vaught, Jr., have since leased to OVINTIV, and consequently, OVINTIV considers their interest to be voluntarily pooled and therefore no longer seeks compulsory pooling of their respective interest. We are going to verbally modify the request for agency action today accordingly. Finally, some of the fee leases that were granted by parties claiming buy-through under the estates of certain deceased parties as identified in the request for agency action, for whom no confirmatory Utah probate proceedings have been initiated, or if initiated, are incomplete as to proper distribution to their heirs or devisees. As such, there is a possibility that some unknown party claiming buy-through or under those estates is unleased and not pooled. Consequently, as to Mary Ellen Slemaker-Benion, who was sent the notice of opportunity to participate but refused to pick it up, and as to such potential unknown heirs or successors, pursuant to the board's order entered on April 13, 2023, the requisite notice of opportunity to participate was published in the Uinta Basin Standard for 2 consecutive weeks. No party responded to that notice or otherwise tendered his or her share of the cost of the well. OVINTIV therefore seeks to have these parties to be compulsory pooled as well and also declared as non-consenting owners. The proof of publication to Ms. Benion and to the unknown heirs or successors was submitted as replacement Exhibit P in this cause. As to the non-consenting parties, OVINTIV seeks imposition of a 300% risk assessment and the terms of a joint operating agreement materially the same as signed by the other working interest owners in the drilling unit, and which terms have been previously deemed just and reasonable by the board in other compulsory pooling hearings. During the recoupment period, the unleased non-consenting owners will be entitled to a 19.802360% cost-free royalty, representing the average weighted fee royalty in the drilling unit calculated as of the date of the spud of the Ute Tribal 1H well. As a reminder, under the statute, tribal lease royalty is not included in that calculation. The board has jurisdiction over this matter pursuant to Utah Code Annotated Section 40-6-6.5 and the implementing regulations found at R649-28A and R649-2-9A. A copy of the request was mailed certified mail to the known parties sought to be compulsory pooled and mailed regular mail to all the other production interest owners within the drilling unit at the last addresses disclosed by the relevant realty records, as well as to the Ute Tribe Ute Distribution Corporation and the Bureau of Indian Affairs due to tribal mineral ownership within the drilling unit. In addition to the published notice of opportunity to participate in the Uinta Basin Standard I previously mentioned, notice of the filing of the request for agency action and this hearing was also duly published in the Uinta Basin Standard on May 3rd, in the Deseret News on May 5th, and in the Salt Lake Tribune on May 7th. On May 10th, the Division of Oil, Gas, and Mining filed a response expressing no opposition to the granting of the request for agency action. No other objections or responses to the request for agency action were timely filed. As a consequence, we request that pursuant to Utah Administrative Code R641-104-150 and R641-108-400, we move for an order of default against those parties sought to be compulsory pooled. And I ask whether the board wants to rule on that at this point or not.
Anyone have any objections to the request? The request is granted.
Thank you, Madam Chairman. With that, I'll commence my examination of Mr. Lair. Mr. Lair, would you please state your name and business address for the record?
Sure. My name is Jordan Lair, and the business address here is 4 Waterway Square Place, Suite 100, Woodlands, Texas, 77380.
And what's your current position with OVINTIV?
My current position is senior land negotiator with responsibility over this drilling unit, among others.
Would you please state for the record what is the corporate and bonding status of OVINTIV?
Sure. So OVINTIV is a Delaware corporation in good standing with its principal place of business for Rockies operations in the Woodlands, Texas. It is duly authorized to conduct business in Utah and is fully bonded with all appropriate federal and state agencies. It is the successor by name change to Newfield Production Company and by merger of OVINTIV Production Incorporated.
All right, Mr. Lair, I'm now going to show you what have been marked as Exhibits C, D, and E for purposes of this hearing. Have you seen those on the screen?
I did.
Okay, were they prepared by you or OVINTIV personnel with your review and input?
Yes, they were.
Turning your attention now to Exhibit C, would you please explain what this shows?
Sure. Exhibit C is the regional locator plat showing the drilling unit comprised of sections 29 and 30 of Township 3 South, Range 3 West, which is approximately 1.5 miles to 2 miles north of U.S. 40 and is just northwest of the Bridgeland community.
Turning your attention now to what has been marked as Exhibit D, would you please explain what this shows and provide a little background about the mineral and leasehold ownership?
Sure. So Exhibit D is a plat of the well location and the oil and gas ownership tracts. It shows the general location of the Ute Tribal 1H well and sections 29 and 30 as it traverses the south half of the drilling unit. As outlined in the RAA, pursuant to the 130-10 order and APDs approved by the division and the BIA, the Ute Tribal 1H well was spud on May 29th, 2022 and completed as a producing oil well with productive intervals within the Ulam Butte member of the spaced Lower Green River-Wasatch Formation. The date of first production was October 7th, 2022. Although it's not reflected on this plat, there is an existing short lateral horizontal well, which is the Ute Tribal 4-29-3-3WH well, which is located in section 29. It was drilled pursuant to the 139-90 order, and production was accordingly allocated on a sectional drilling unit basis. As Mr. McDonald mentioned, the SNR Raptor Limited Partnership went non-consent, and its interest was compulsory pooled under the 139-104 order. However, it subsequently assigned its interest to Blackstone Minerals Company Limited Partnership and Hertz Energy Capital LLC, both of which are now leased. Per the 130-10 order, allocation from the existing short lateral horizontal well converts to the DSU basis as of November 1st, 2022, being the first day of the month following first production of the Ute Tribal 1H well. At that time, per the 130-110 order, any recoupment then owed is waived. As shown in the plat, there are 5 different oil and gas tracts in the DSU. Tracts 1 and 5 are tribally owned. And as provided in the compulsory pooling statute, the royalty under those leases covering those tracts, which are not included in the calculation of the average weighted landowner's royalty applicable to unleased non-consenting owners. And then the remaining tracts shown on the plat of this exhibit are all owned in fee.
Again, your point there that the tribal tracts, the royalty on those tracts is not included in the average weighted calculation, correct?
That's correct.
All right. Turning your attention now to what has been marked as Exhibit E, would you please explain to the board what this shows and its significance?
Sure. So Exhibit E is just a plat showing the DSU working interest ownership. One thing to note here, and as Mr. McDonald mentioned, Covey and the estate of George Vaught had leased after submittal of the request for agency action, and this exhibit does not account for their interest now being leased.
In that regard, Madam Chairman, if the board would like a updated exhibit to reflect the interest, we'll be happy to provide that.
Yes, I think that would be good.
All right, we will do that. All right. Go ahead, Mr. Lair.
Certainly. So the key point of this exhibit is to show that OVINTIV is the majority lessee / working interest owner in the DSU and is the operator of the Ute Tribal 1H well. The additional lessee / working interest owners in the DSU are Uinta Wax LLC, Salt Creek Oil and Gas, PEC Exploration LLC, Ron Petroleum Incorporated, and Kaiser Francis Oil Company. All have signed JOAs with OVINTIV, the terms of which contractually govern well elections, including the elections made on the Ute Tribal 1H well. OVINTIV, as the designated operator, has recorded a pooling declaration pooling the fee leases pursuant to the authorization contained in their various pooling clauses. OVINTIV also is in the process of submitting an amended communitization agreement pooling these leases with the tribal leases.
All right, I'm going to turn your attention now to what have been marked as Exhibits H through M. Do you have those in front of you, or do you recognize those?
I do. I have them in front of me.
All right. For the board's information, Exhibits F and G that were submitted are no longer required since the Covey Minerals and the Vaught estate interests are now leased. Turning again to Exhibits H through M, are these official business records of OVINTIV?
Yes, they are.
And what do they constitute?
So these are the various notice of opportunity to lease and or participate sent for the Ute Tribal 1H well, along with proofs of delivery, a JOA, and Exhibit N and O were attached to each.
All right, we'll get to Exhibits N and O in a minute. As a reminder to the board, each of these notices with the reference attachments reflect compliance with the regulatory requirements under R-649-1-1 and R-649-28A. Okay, turning your attention, Mr. Lair, to Exhibit H, please explain what that document pertains to and its significance.
Sure, that's the notice of opportunity to participate submitted to Kate F. Markham, who is the apparent owner claiming by, through, or under the estates of Harley B. Markham Sr., Ruth McCormick Markham, and Harley B. Markham Jr. Of an unleased, undivided 0.057965% oil and gas interest in Tract 4, which equates to a 0.016237% working interest in the DSU. Further shows that receipt was confirmed on October 24th, 2022, and we've received no response to the same.
Now turning your attention to Exhibit I, would you again please address what that shows and its significance?
Sure, that is the notice of opportunity to participate submitted to Mary Ellen Slimmaker Benyon, who is the owner of an undivided 0.733263% interest in Tract 4, which equates to a 0.205403% working interest in the DSU.
What was the status of that mailing?
So as you had referenced at the beginning of this, the status of the mailing is she had failed to pick it up, even though it's been delivered to a P.O. box we've previously confirmed for her, and therefore we also submitted this via publication, and no response has been received.
Now turning your attention to Exhibit J, would you again please explain what it represents and its significance?
Sure. So Exhibit J is the notice of opportunity to participate for Tracy Lee Markham Sherrill, who is the apparent owner claiming by, through, or under the estates of H.B. Markham, Ruth McCormick Markham, and H. Bruce Markham Jr. Of an unleased, undivided 0.28983% interest in Tract 4, which equates to a 0.008119% working interest in the DSU. Shows further that receipt was confirmed on October 28th, 2022, and again, no response has been received.
Turning your attention to Exhibit K, same questions concerning what it is and its significance.
Sure, it's the, again, notice of opportunity to participate for Susan Renee Dukes, who is the apparent owner claiming by, through, and or under the estates of Harley B. Markham Sr., Ruth McCormick Markham, Harley B. Markham Jr., Lillian Mae Moley Markham, and Christopher Dukes of an unleased, undivided 0.0048303% interest in Tract 4, which equates to a 0.0013527% working interest in the DSU. Again, receipt was confirmed as of October 24th, 2022, and no response has been received.
Now turning to Exhibit L, again, the same questions and what it involves and its significance.
Sure, this is the notice of opportunity to participate for Scott Dukes, who is the apparent owner claiming by, through, or under the estates of Harley B. Markham Sr., Ruth McCormick Markham, Harley B. Markham Jr., and Lillian Mae Moley Markham of an unleased, undivided 0.0048303% interest in Tract 4, which equates to a 0.0013527% working interest in the DSU. Receipt was confirmed as of October 24th, 2022, and no response has been received.
Bring your attention then to Exhibit M. Again, same questions about what it involves and its significance.
Sure, this was the notice of opportunity to participate delivered to Kent Dukes, who is the apparent owner claiming by, through, or under the estates of Harley Bruce Markham Sr., Ruth McCormick Markham, Harley Bruce Markham Jr., and Lillian Mae Moley Markham of an unleased, undivided 0.0048303% interest in Tract 4, which equates to a 0.0013527% working interest in the DSU. Receipt was confirmed as of October 24th, 2022, and no response was received.
All right, turning to Exhibit N, would you please explain what that shows? Again, it's no PowerPoint on this, but go ahead and explain what Exhibit N is.
Sure. Exhibit N is the survey plat of the Ute Tribal 1H well, sent with each of these notices.
And turning your attention to Exhibit O, again, no PowerPoint on that, but what does that exhibit pertain to?
Sure. Exhibit O is the AFE sent with each notice. As Mr. Ellison will testify, the AFE was a reasonable estimate of the actual costs incurred in the drilling of the Ute Tribal 1H well.
All right, would you go ahead and address about the unknown heirs or successors of decedents that I had mentioned in my opening remarks?
Sure. As we discussed, several lessors claim title in these lands through one or more of the estates of the following deceased record mineral interest owners: Don T. DeJournette, Jeffrey J. Noble, Harley Bruce Markham Sr., Ruth McCormick Markham, Lillian May Moley Markham, Harley Bruce Collins Markham, Harley B. Markham Jr., Nancy Eves Nikora, Mary A. Eves, Michael P. McDermott, Minerva E. McDermott, William H. Markham, William Lee Markham, George G. Vaught Jr., and Christopher Dukes. For each of these, either no Utah probate of the estates have been initiated, or if filed, they are incomplete in that there are no proper distributions made to the heirs or devisees. And although based on heirship affidavits and other inquiries and research done by OVINTIV's lease broker, and except for the specific parties previously identified to be compulsory pooled and declared as non-consenting owners, OVINTIV believes it and the other voluntarily pooled working interest owners have leased all of their successors without an order from a Utah court confirming their succession. The possibility exists that unknown successors may successfully establish succession. Such owners would be unleased, and therefore OVINTIV seeks to compulsory pool their interests.
And I would refer the board to what has been filed as Replacement Exhibit P, which is the affidavit showing the proof of publication in the Uinta Basin Standard for the 2 consecutive weeks as required under the regulations. Did you receive any responses to that published notice?
I did not.
All right. Turning your attention to what has been marked as Exhibit Q, again, I don't have a PowerPoint for this, but it's also Exhibit 1 to the request for agency action. Was that document prepared by you?
Yes, it was.
And go ahead and explain what it shows and the relevant portions for purposes of this hearing.
Sure. So this is the joint operating agreement, which is a form utilized that is an industry standard form supplied by the American Association of Professional Landmen. It's Form 610. This is the 1989 version with modifications to address horizontal wells. Exhibit Q is materially the same Form JOA sent with all of the mailed notices previously outlined. Terms and conditions contained therein, including the modifications made, are consistent with and commonly found in more recently developed horizontal well drilling units, including the JOAs signed by the other voluntarily pooled working interest owners in the DSU. OVINTIV has prepared identical terms for other drilling units it has operated and has agreed to such terms in other drilling units in which it is a non-operator, including drilling units operated by Uinta Wax, Javelin, and other major Uinta Basin operators.
All right, turning your attention to page 7 of the joint operating agreement, would you please outline that, what the paragraph 6B2 provides?
Sure, that's the non-consent penalty. It's 100% slash 300% is provided. And it's the same as contained in the JOA signed by Uinta Wax et al.
All right, turning your attention to what is Exhibit C to that joint operating agreement, would you please outline what the significant portions of that document provides?
Sure, Exhibit C of the JOA is the COPUS accounting procedure. Again, this is a standard industry form, almost universally utilized and similar to other JOAs in the Uinta Basin. Page C3, Article 3B sets out the interest rate at the prime rate as published in the Wall Street Journal plus 3%, which is fair compensation and there to encourage timely payment of chargeable costs and expenses. Page C9 outlines the overhead charges, which in this case is $10,090 for drilling, and then 1,090 for producing wells.
Right, is it your expert opinion then that the terms and conditions of the proposed joint operating agreement are fair and reasonable and consistent with those accepted by other working interest owners in this drilling unit and with those commonly accepted by industry and in particular the Uinta Basin with respect to horizontal well operations?
Yes, it is.
All right. Regarding the average weighted fee landowner's royalty, again, for the board's information, Utah Code annotated section 40-6-6.5, subparagraph 6 and 8, provide that a compulsory pooled unleased owner is entitled to payment of the average weighted fee landowner's royalty during the payout period, and the tribal royalty is not included. Mr. Lair, turning your attention to what has been marked as Exhibit R, this is a 3-page exhibit. I'm just going to show you the last page for purposes of this. Was this document prepared by you?
Yes, it was.
Please explain to the board what it shows.
Sure, this reflects the calculation of the average weighted fee landowner's royalty for sections 29 and 30 of the drilling unit as of the date of spud of the Ute Tribal 1H well, the summation of which is the average weighted fee royalty being 19.802360%.
All right, now, Mr. Lair, I'm going to direct your attention to the certificate of service, which is a pleading prepared by my office and already on file in this cause. Do you have that in front of you?
I do.
All right. Do you recognize the parties listed on that document?
I do.
Who are those
person
parties?
shown?
And how are the
Yes, I do.
address? Go ahead. And how are the addresses shown compiled?
Sure. The persons shown are all of the production interest owners within sections 29 and 30. The addresses were derived from a title opinion effective as of March 2nd, 2022, as updated by a search of the county records by our broker, Lone Wolf, and by searching our own internal records.
All right, referring the board to Exhibit Z as supplemented, these are the true and correct copies of the certified mailing receipts received by my office, confirming receipt of a copy of the request for agency action by the parties to be compulsory pooled who were known or returned as unclaimed or undeliverable, or if we didn't get a green card back, the USPS inquiry of the mailing. With that, Madam Chairman, that concludes my examination of Mr. Lair.
Board, do you have a? Oh, I'm sorry.
It's division.
Sorry, that's what I meant.
Madam
I'm
Chair,
looking at you.
with permission from the board, I'd like to have Dustin Doucette, who's a petroleum engineer with the division, ask a few questions directly. Is that okay?
Yes.
Yeah, Dustin Doucette for the division. If you could turn to Exhibit E really quick. I know you indicated you'll provide an updated exhibit here for the compulsory pooled interest, and that amount is pretty low already, but do you happen to know what that percentage, that updated percentage is?
Yes, sir. So at present, it's less than 0.25%. It's 0.242846%.
Okay, thank you. That's the only question I had.
Any other questions?
Yes, just one question. Mr. Lear, the regulations require that a notice of opportunity to participate include the approximate surface and bottom hole location of the subject well by county, township, range, section, quarter section, or substantially equivalent lot, and footages from directional section length. I was just wondering, how does OVINTIV accomplish that particular requirement for a notice of opportunity to participate?
So I believe it was Exhibit N, that is the surveyed plat that would contain all that information for the pertinent well.
Okay, perfect. Thank you, Mr. Lear. That's the only question I had.
Board, are there any questions?
I have a couple.
Okay.
So one of the unfound or unlocatable parties is this Mary Slamick or Benyon. I recognize her name showing up in a lot of these compulsory pooling. Have you ever had contact with her and had a conversation as to why she doesn't pick up the mail or any just curious?
So my understanding is that I think she inherited this interest from, I think it's her father, and that, he was more savvy and in the business of mineral buying. And I think her brother had been handling a lot of this for her. And I don't know this as a fact, but my assumption is that she's just not able to kind of deal with this for herself. And so, that's why I think you are seeing not only OVINTIV, but other parties have to bring forward actions to compulsory pull her.
Because, I do see leased sleigh makers in the list there.
Yeah.
And so, and they can't assist in any way in helping her make a decision?
To be honest, I don't know that anyone's really been able to engage with her. I mean, we've tried not only that PO box, but other addresses, and short of like trying to find a home address and have somebody go knock on a door, we haven't really been successful. But can reach out to some of the other relatives. I think they're likely cousins or other distant relatives, and see if maybe somebody's got a means of getting in contact with her.
Okay. I neglected to disclose that my family does have an interest in this Section 29, so I'll be participating but not voting. So I wanted to make sure we're all good with that.
No objection from OVINTIV standpoint.
No objection from the division either.
Okay, thank you. And then one, Mr. McDonald, you mentioned that an updated offer to participate or lease that includes their actual interest was sent or is being sent to them?
No, these notices were sent back in October before we had the hearing in
Okay.
March. But what OVINTIV, and Mr. Lear can confirm for the record if it's necessary, that OVINTIV going forward with any notices going forward since March, they're going to include that information.
Okay.
Per the board's direction or
Not
preference.
doing it retroactive on this
No,
one, just
no.
going forward. Okay, thank you.
I have anybody, other questions? So if you had non-consent people in the original well who have now leased, has the weighted average royalty changed on each of these wells?
It would have been waived on the existing wells, so it doesn't matter anymore. It's only going forward with this well.
Okay,
And whether they're consent or non-consent in this well.
okay, thank you. Questions? Back to you, Mr. McDonald.
Thank you, Madam Chairman. With this, I'll commence my examination of Mr. Allison. Mr. Allison, would you please state your name and business address for the record?
Sure. Brett Allison, 4 Waterway Square Place, Suite 100, The Woodlands, Texas, 77380.
And what is your current position with OVINTIV?
I'm a reservoir development engineer overseeing our UNTA asset.
Since this is your first time testifying in front of the board, would you please, for the record, just briefly outline your education, work experiences in the Uinta Basin or analogous basin, any certifications, and if you've ever testified in front of another oil and gas commission and been recognized as an expert?
Sure. Good morning, everyone. As I said, my name is Brett Allison. I have been with Newfield Exploration, now OVINTIV, for going on 6 years at this point. I've been in my current role as a reservoir development engineer for about 1.5 years. Prior to that, I worked as a facilities engineer over our Rockies asset, which is the Bakken in North Dakota, and Uinta Basin, engineering, designing, and executing surface production facilities to aid in horizontal well development across each of those fields. Prior to that, I worked as a field production engineer in our southern Oklahoma asset, monitoring workover rig operations and optimizing field production operations throughout that basin. And then prior to that, I worked as a rotational engineer within the new grad program within Newfield, circulating through our reservoir and our drilling and completion operations, mostly just monitoring our reservoir performance and D&C ops throughout our Uinta Basin asset. Like I said, I've been with the company for about 6 years now, and I've been a licensed professional engineer in the state of Texas to practice petroleum engineering for 1.5 years.
All right, could you just outline also what degrees you own and from where?
Sure. I have a Bachelor of Science degree in petroleum engineering from Colorado School of Mines, graduated in 2017.
All right, Madam Chairman, with Mr. Allison's resume and that summary of his work experience and the other matters, I would ask that the board recognize him as an expert in petroleum engineering for purposes of this cause.
So recognized.
Any objection?
No objection from the division.
I'm sorry.
Thank you. And Mr. Allison, now turning your attention to what has been marked as Exhibit S, would you please, or was this prepared by you or OVINTIV personnel with your review and input?
Yes.
All right, would you please explain what this shows?
Yes, this is a summary of the actual costs incurred in the drilling, completing, and operating of the Ute Tribal 1H well through March 31st of 2023.
And how does this relate to the AFE that was sent out with the notices and to the other working interest owners when the well was proposed?
It is within reasonable variance of the original AFE. The only overage that we had experienced was on the drilling side due to a required sidetrack due to a downhole tool failure.
And is it your expert opinion then that the cost incurred were fair, reasonably, and necessary, and that the well was deemed economically feasible, as that term is used in the 130-10 order to drill?
Yes, it is.
Right? Would you please outline for the board what are the estimated plugging and abandonment costs for the Ute Tribal 1H well?
Yes, we're currently running with a $75,000 per well P&A cost estimate, which is consistent with the Uinta Basin P&A costs charged to and by OVINTIV based upon 100% working ownership.
Now turning your attention to what have been marked as Exhibits T and U, do you see those on the screen or do you have those in front of you?
Yes, I do.
Were they prepared by you or OVINTIV personnel with your input and review?
Yes, they were.
Turning your attention to Exhibit T, would you please explain to the board what this shows and its significance to this cause?
Exhibit T is a plat of the nearby existing horizontal well developments at the time of the Ute Tribal 1H well when it was drilled. It was drilled concurrently with the other laydown wells in its near vicinity. I will note that the wells that are in section 25 and 26 of Township 3 South, Range 4 West, are Javelin operated wells and not OVINTIV wells. Therefore, no data was available to compare and analyze within that DSU.
So there was relatively little information regarding horizontal wells drilled in this area for OVINTIV, is that correct?
That's correct. We had very limited or no well control in this area.
All right, turning your attention now to Exhibit U, would you please go through the bullet points shown on here and how it relates to the risks that OVINTIV assumed at the time of drilling?
Sure. From a pre-spud perspective and drilling and operational challenges that we are expecting going into it, this well is in close proximity to an offset perpendicular horizontal well in which depletion can occur, which can inhibit mud properties and lead to lost circulation and hole stability concerns. On top of that, the Uteland Butte inherently it tends to have a higher clay intervals, which can have the potential to lead to collapse and stick drill pipe and/or casing. We didn't see too much of that issue during the actual execution of these wells. However, we did see, the actual risk we did see was an RSS tool failure downhole that led to within the lateral that led to a sidetrack in the lateral, and then just generalized inflation pressures that affected all operations.
Is it your expert opinion then, for those reasons, a 300% risk assessment award is justified?
Yes.
Madam Chairman, that concludes my examination. Mr. Allison.
Division?
The division has no questions for this witness.
Board?
Just a matter of curiosity, Mr. Allison, on the artificial lift, did the 1H go immediately to artificial lift? Is there any flowing of these wells before you put on artificial lift?
Yes, this well did flow. I don't know the exact time frame, but it usually flows for roughly 1 to 3 months, and then we install artificial lift on the well. It's currently on artificial lift.
Thank you.
Just an approximation. When do you believe it will pay out 300%? I just pulled the well up. It's produced 217,000 barrels so far, and so that would be at least, a payout. It's paid it for itself. What would you estimate a 3 times payout?
I don't have the numbers in front of me. I don't have the forecasts in front of me right now, so it'd be very difficult to estimate. I would I would mention that, as you all know, that the decline on these wells is not linear. So it will tend to get into that long tail production a little bit more so as it gets later in its life.
But based on its early production, you would expect it to pay to produce 300%? Or cover that?
Like I said, I do not have the forecast in front of me in terms of total EUR for the well. It has come online as a pretty strong well thus far, and I don't have the information in front of me to estimate what its total estimated ultimate recovery is going to be, though.
Okay.
And I guess the one thing I'd add to that question is, price environment really dictates, especially when the production kind of tails off, excuse me, payouts and things of that nature. And that's obviously something that's hard to predict long term.
Any other questions? Back to you, Mr. McDonald, for closing.
Thank you, Madam Chairman. At this time, I would move for admissions of Exhibits A through E, H through O, Replacement Exhibit P, Q through U, and Z is supplemented. We're not submitting Exhibits F or G because they are not necessary given the leasing status of the Covey and Vaught estates. And again, pursuant to your direction, we will file a corrected Exhibit E to account for those two interests and update it to the lower amount of the interest being compulsory pooled.
Okay, I have all exhibits except F and G.
Correct.
Madam Chair, can you turn on your microphone?
All exhibits except F and G.
Correct.
Okay.
Any objection from the division?
No objection from the division.
Anything else, Mr. McDonald?
No, that's all. I'll reserve just a final closing remark once the division's made its statement.
Okay.
Yeah, the division is supportive of granting the request as drafted and requested and as modified here orally by Mr. McDonald. The division notes that Mr. McDonald reached out and we were able to collaborate on that previous order that was not mentioned originally in the RA and work through that issue, and the division does not view it as an issue that should hold back granting the relief requested and as modified. So overall, the division is supportive.
Thank you. Final thoughts?
Thank you, Madam Chairman. With that, again, as modified by the motions that I made earlier, we believe that all the statutory and regulatory requirements have been met to grant the request for agency action. We thank the board for its attention and particularly to allow the witnesses to appear virtually. And we also thank the IT group for their efforts in making this go very smoothly. Thank you.
Thank you. Board, do we need to deliberate or are we ready to vote? Can I get a motion?
Madam Chair, I move that we grant the relief as requested.
Second.
Thank you. All those in favor? Aye. Any opposed? Thank you. Thank you, Mr. McDonald.
Okay, and that was a 4-0 unanimous vote with Mr. Moon abstaining from the vote. Is that correct?
Right.
All right, and I will be happy to prepare the order with division's input and board's counsel.
Great. We look forward to that.
Thank you.
Thank you. All right. You're back with us, Mr. McDonald. We're moving on to item number 2, docket number 2023-021, cause number 475-08, in the matter of the request for agency action of Robert L. Bayless Producer, LLC, for an order, 1, partially vacating the board's order entered into cause number 270-10, and 2, suspending Utah Admin Code Rules R 649-3-2, R 649-3-10, and R 649-3-11, sub 1 and sub 2, as to the Pelican Shallow Federal Unit comprising of portions, sections 20, 21, 28, and 29, 7 South, 20 East, U.S.M. Appearance of counsel.
Thank you, Madam Chairman. Fred McDonald of Counsel with Lear & Lear on behalf of petitioner Robert L. Bayless, Producer, LLC.
Madam Chairman, Trevor Guel with the Utah Attorney General's Office on behalf of the Utah Division of Oil, Gas, and Mining.
Very good. Mr. McDonald?
Thank you. With me today testifying on behalf of the petitioner are Mr. Cranford Newell Jr., who's the land manager in person, and on virtually appearing, thanks to the board's order on May 16th, is Mr. Nathan Denson, who is the senior operational manager. I would ask that they be sworn in at this time.
Gentlemen, do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Right. Nathan, you may want to mute until it's your turn for testimony, just because we're picking up a little bit of feedback, okay? Thank you. Members of the board, the resumes of both witnesses were collectively submitted as Exhibit A in this cause. If separately and individually asked about the contents of their respective resumes, the witnesses would confirm the same. Mr. Newell will be a fact witness, and Mr. Denson will be appearing for the first time before the board, so I will qualify him as an expert in petroleum engineering at the commencement of his testimony. Again, in accordance with board practice, I will be moving for admission of the exhibits at the end of our presentation in chief.
Okay.
Members of the board, Bayless has applied for and received preliminary approval from the Bureau of Land Management of the Pelican Shallow Federal Exploratory Unit, comprised of portions of sections 20, 21, 28, and 29 of Township 7 South, Range 20 East in Uinta County, but limited in depth from the surface to the base of the Wasatch Formation. Bayless is in the process of securing final approval from the Bureau of Land Management, which it expects to receive very shortly. As certain of the exhibits will reflect, the surface of almost the entirety of the unit lands is covered by the Pelican Lake. Consequently, there will be limited drilling pad availability for unit development. Currently, the unit lands are subject to the board's order entered in cause number 270-10, entered in 2018, which established overlapping drilling units for production from the Eocene Middle and Lower Green River Formations and portions of the Paleocene Wasatch Transitional Formations. Specifically, that order created 40-acre drilling units for vertical or directionally drilled wells with 1 well per drilling unit, for 640-acre or sectional drilling units for short lateral horizontal wells with up to 24 such wells to be drilled per drilling unit, and finally a 1,280-acre or 2-sectional stand-up drilling unit for long lateral horizontal wells comprised of sections 20 and 29 and sections 21 and 28 respectively, with up to 24 such wells per drilling unit. Finley Resources, Inc. was the petitioner in that cause. A true and correct copy of the 270-10 order was submitted as part of Exhibit B in this cause. Pursuant to the 270-10 order, Finley drilled 2 wells, one short lateral horizontal well located in the west half of Section 20, and one long lateral horizontal well located also in the west half of Section 20 and also into Section 29. Both wells are physically located outside of the unit. Finley has since assigned its interest in the relevant leases in the unit lands to Bayless, but reserved all rights in and to those 2 wells. In order to develop the unit properly and orderly, especially in light of the surface restrictions of Pelican Lake, Bayless is requesting the board to grant 2 reliefs. First, Bayless is requesting the board to vacate the 270-10 order as to the unit lands, except in order to avoid upsetting existing contractual rights, it is to remain in effect only as to the 2 Finley wells as relating to the unit lands. Secondly, presuming the 270-10 order is so vacated, the general well siting rules would otherwise become applicable to the unit lands, and as previously outlined, newly drilled wells would almost always require exception locations because of Pelican Lake. Consequently, Bayless also requests the board suspend those general well siting rules as applicable to the unit. As to that latter request, as the board may be aware, our 649-2-3 allows suspension of the general operational rules as to the lands within the approved federal units. The board has granted this relief on numerous other occasions as outlined in the request for agency action. A true and correct copy of the R649-2-3 as well as the applicable general siting rules were submitted as the remainder of Exhibit B in this cause. As many of the board members are aware, units allow for the most efficient and economic manner of exploration and development because the unit operator can develop on the basis of reservoir characteristics and not based on some arbitrary spacing or well siting pattern. Our 649-2-3 recognizes this and allows for the suspension of existing board rules as to federal units so long as the conservation of oil and gas and the prevention of waste are accomplished thereby. The evidence presented today will show that the Pelican Shallow Lake Unit Agreement and operations conducted thereunder are intended to and will accomplish the conservation of oil and gas and the prevention of waste. There are a couple of important caveats to Bayless' request. In addition to the continuation of the 270-10 order to the two Finley wells, in order to protect correlative rights, Bayless also agrees that no unit well may be drilled closer than 460 feet to the unit boundary without an exception location approval of the division or the board in accordance with R 649-3-3. Also, the regulatory requirements to provide a directional survey as to any directional or horizontally drilled well remains in place. The board has jurisdiction over this matter pursuant to Utah Code annotated section 40-6-5, subparagraph 3B, and Utah Administrative Code R 649-2-3. A copy of the request was sent via certified mail to all production interest owners within sections 20, 21, 28, and 29 as to the unitized formations, and to the Bureau of Land Management, both to the State Office and the Vernal Field Office, as only federal leases are affected, and the Bureau of Land Management is the supervising agency over the unit. All of these were sent to the last addresses disclosed by the Bureau of Land Management and Uena County Realty Records, as well as Bayless's internal records. Notice of the request for agency action in this hearing was also duly published in the Uena Basin Standard and the Vernal Express on May 3rd, the Deseret News on May 5th, and Salt Lake Tribune on May 7th. On May 8th, 2023, Finley filed a letter expressing it had no objections and supported Bayless's request to vacate spacing in the unit area. On May 10th, 2023, the division filed a response expressing no opposition to the granting of Bayless's request either. No other objections or other responses, including any from the Bureau of Land Management, were filed. With that, I'll commence my examination. Mr. Newell. Mr. Newell, would you please state your name and business address for the record?
Yes, my name is Cranford D. Newell Jr. Address is 621 17th Street, Suite 2300, Denver, Colorado, 80293.
And what is your current position with Bayless?
My current position with Robert L. Bayless Producer is land manager. Part of my duties is supervision of our Uinta assets with accessing and control over land records related thereto.
For the record, would you please state the corporate and bonding status of Bayless?
Yes, Bayless is a Colorado limited liability company with its principal place of business in Denver, Colorado, and is duly qualified to do business in the state of Utah.
All right, and what is its bonding status?
Bayless is fully and appropriately bonded with all relevant federal and state of Utah agencies.
All right, turning to your attention what have been marked as Exhibits C, D, and E. E is more completely shown here. Do you recognize these documents?
I do.
Were they prepared by you or Bayless personnel with your input and review?
They were.
All right. Turning your attention to Exhibit C, would you please explain to the board what this shows?
Yes. On the left-hand side, you'll see a regional map, generally showing the location of the Pelican Shallow Unit southwest of Vernal. Also on the right side of Exhibit C, you'll see the surface of the unit area is almost entirely covered by Pelican Lake, as previously mentioned by Mr. McDonald.
Now turning your attention to Exhibit D, would you please outline what this shows and its relevance to the cause?
Yes. This is a plat of unit and the leaseholds within our unitized lands. It is limited to the depths from which the surface to the base of the Wasatch Formation, the stratigraphic equivalent of which is outlined in the request for agency action. It is made up of 3 tracts, all 3 tracts being federal leases, those being UTU 74417, UTU 75093, and UTU 89145. Bayless has acquired all of its operating rights to the unitized formations from Finley and Uwinnawax, except for the rights to 2 Finley-operated wells, which Mr. McDonald previously referred to. Once again, those wells are the Pelican 20S-720E-H7UB, which is classified as a short lateral horizontal well. The second well being the Pelican 20S-720E-H6CP, which is classified as a long lateral horizontal well. Both of these wells are physically located outside the bounds of our unit. Bayless's request to vacate the 270-10 order as to the unit lands excludes its application to those 2 wells, only so as to not upset existing contractual production allocation rights.
All right, I'm going to turn your attention now to Exhibit E. This is a full document of the unit agreement for the Pelican Shallow area. I'm only going to show the relevant portions for purpose of this cause on here. Would you please outline or read into the record what Exhibit E1 shows? This is, and where it appears in the unit agreement.
Yes, there are 2 important articles I'd like to point out. The first being the 4th recital on page 1, where it states, "It is the purpose of the parties hereto to conserve natural resources, prevent waste, and secure other benefits obtainable through development and operation of the unit." The second article I'd like to point out is Article 16 on page 8, titled Conservation. It states, "Operations hereunder and production of unitized substances shall be conducted to provide for the most economical and efficient recovery of said substances without waste, as defined by or pursuant to the state of Utah or federal law or regulation." The formal approval and certification from the BLM will include the agency's certification and determination that the unit is necessary and advisable in the public interest for the purpose of more properly conserving the natural resource.
All right, would you confirm for the record whether Bayless will operate the unit under these governing principles?
It will.
All right, would you also confirm that Bayless will maintain a 460-foot set-off from unit boundaries, or as necessary, will seek exception locations approvals?
Yes, it will.
Finally, would you confirm that Bayless will provide directional surveys as required under R649 3-11 subparagraph 3?
Yes, it will.
All right, now turning your attention to Exhibit F. There's no PowerPoint for this. Do you recognize this document?
I do. It is our preliminary approval letter received from the Bureau of Land Management for the Pelican Shallow Unit.
All right, and this was an official business record of Bayless, is that correct?
Correct.
All right, can you just kind of outline, is there any changes from what this letter says?
There is. Since its issuance, the northwest of Section 29 has been excluded from the unit boundary, and the unit will now include 999.646 acres.
All right, what's the status of this application? What has Bayless done since it received the preliminary approval to receive final approval?
Since receiving preliminary approval, Bayless has sent out joinder packets and attained all necessary operational right joinders as well as record title joinders, and filed on May 11th, 2023 for final approval with the Bureau of Land Management.
Have you heard any response yet from the BLM? Has there been any concerns or expressions, and do you anticipate that they'll approve it in due course?
No, we have not received any concern from the Bureau of Land Management. Currently, the plan moving forward is Bayless expects to have an approved APD for the initial unit earning well by June 1st, and will drill once the unit is formally approved by the Bureau of Land Management and presuming board approval of our current RAA.
Now I'm going to turn your attention to the certificate of service, which was prepared by my office and is a pleading on file in this cause. You see the names and all that. Do you recognize those names and parties?
I do. I recognize the names as all production interest owners in sections 20, 21, 28, and 29 as to the unitized formations, and the BLM, both state and vernal field offices, as lessor under federal leases and as their unit administrator.
And how were those names and addresses compiled?
They were compiled from a search of BLM and Uinta County records and from Bayless internal land records.
All right, turning the board's attention to Exhibit Z, this is the true and correct copies of the return receipts, green cards that we received for the mailing of it, and it will reflect that all of the parties that are listed on the certificate received a copy of the request. Madam Chairman, that concludes my examination of Mr. Newell.
Division?
The division does not have any questions for this witness.
Board? Okay, moving on.
Thank you. With that, I'll commence my examination of Mr. Denson. Mr. Denson, please state your name and business address for the record.
Morning. My name is Nathan Denson. Business address is 621 17th Street, Suite 2300, Denver, Colorado, 80293.
Would you please state for the record what is your position with Bayless?
My current position is Senior Operations Manager, responsible for drilling, completions, production, and reservoir for all Bayless-operated assets. My main area of focus has been in the Uinta Basin recently.
All right, since this is your first time testifying in front of the board, would you please do a brief outline of your education, work experience, particularly in the Uinta Basin or Piceance Basin or analogous basin, any certifications or publications are recognized by state conservation commissions or things of those nature?
Sure. I earned a Bachelor of Science degree in Geological Engineering from the South Dakota School of Mines and Technology in 2006. I started out of university working in the field as a drilling fluids engineer for the oil field service company Baker Hughes. And the last 12 years has been working for oil and gas producers, specializing in drilling engineering. The majority of my career has been spent in the Piceance and Uinta Basins. I've also worked internationally in Australia, where I'm recognized as a chartered engineer in the colleges of mechanical and petroleum engineering.
Madam Chairman, with that testimony and his resume, I would ask that the board recognize Mr. Denson as an expert in petroleum engineering for purposes of this cause.
Division, do you have any?
No objections to him being recognized as an expert for this cause.
Board, any? Mr. Denson is qualified.
Thank you. Mr. Denson, now turning your attention would have been marked as exhibits G through P. You recognize all these exhibits?
You.
Okay, were they prepared by you or Bayless personnel with your review and input?
They were.
Okay, turning your attention to exhibit G, would you please explain what this shows and its significance?
Exhibit G is a subsea contour map of the Wasatch Formation top with 100-foot contour intervals. The Wasatch Formation in this area dips to the northwest. The area in red is the Bayless unit boundary. Also reflects the two Fenley horizontal wells, the Pelican 20S-720E-H7UB, also known as, or I will be calling in this presentation, just H7UB, and also Pelican 20S-720E-H6CP, which I will be calling H6CP in this presentation. Also shows a cross-section reference line from A to A prime.
All right, turning to exhibit H, please explain what this shows and its significance.
This is a cross-section flattened on the hard marker member of the Green River Formation, also known as the Black Shale member of the Green River Formation. That's shown fourth up from the bottom of the cross-section there. It shows the uniformity of targeted unitized zones across the unit area. And there are call-out boxes on the right that indicate the targeted zones for the two Fenley horizontal wells to the west of the unit boundary. The longer lateral being the H6CP and the H7UB.
Now turning your attention to exhibit I, please explain what this shows.
Exhibit I reflects the minimum distances from the two Fenley horizontal wells to the west, to the western unit boundary. I don't know if you can see on the exhibit, but the H6CP's closest distance to our unit is 525 feet, and the H7UB is 645 feet.
Now turning your attention to exhibit J, please explain what this shows.
This was originally prepared by Fenley and submitted and admitted into evidence as Exhibit O in the 270-10 hearing. On the left shows Axia's interpretation of the fracture orientation in this area. On the right is a revised interpretation based on Finley's microseismic data of the fracture orientation. AXIA originally stated it was north to 57 west for the max horizontal stress orientation, and it was revised to north 73 west by AXIA, by Finley, based on their microseismic data.
Now turning your attention to Exhibit K, please explain what this shows.
This is a petrophysical analysis using the A' well from the cross-section in Exhibits G and H, the Aurora Federal 6-28D-7-20. This analysis estimated original oil in place per section in this area. The brackets show the longer lateral H6CP and H7UB Finley horizontal wells. To be noted that this was used in our volumetric drainage calculations.
Now turning your attention to Exhibit L, please explain what this shows.
This reflects the decline curve of the H6CP well, which is the longer lateral well, and estimated ultimate oil recovery in the text on the right of 286,134 barrels, which was used in our volumetrics drainage calculations.
Excuse me. Going back to Exhibit M, please explain how this relates to those prior exhibits and the significance of this exhibit.
Based on exhibits K and L, a 353-foot drainage radius was determined. This is relevant to the minimum distance from the unit as reflected on Exhibit I.
And this is for the longer lateral well, is this correct? The Finley well, that's the longer lateral well.
That's correct.
All right, now turning your attention to Exhibit N, please explain what this shows.
This reflects the decline curve of the H7UB well and estimated ultimate oil recovery in the text on the right of 45,130 barrels, which was used in our volumetrics drainage calculations.
Now turning to Exhibit O, please explain what this shows.
Based on the exhibits K and N, a 241-foot drainage radius was determined, and this is relevant to the minimum distance from the unit as reflected on Exhibit I and summarized in the next exhibit.
And moving to that next exhibit, which is Exhibit P, please explain what this shows.
Sure. This is a compilation of exhibits I, M, and O with a map showing the distances from the Finley horizontal wells and the Bayless unit boundary. The table on the left summarizes the calculated drainage radiuses and minimum distances from the unit boundary in both horizontal wells.
So it is your expert opinion then that there should be little or no interference between the Finley wells and the unit wells, thereby protecting correlative rights of the interest owners in each?
Yes.
Madam Chairman, that concludes my examination. Mr. Denson.
Thank you. Division? F.
No questions for this witness.
Board? Any questions? Okay. Back to you, Mr. McDonald.
Thank you, Madam Chairman. That concludes our presentation in chief. At this time, I would move for admission of Exhibits A through P and Z.
I noted from the copies here, Exhibit E has an E2 with it.
That's the PowerPoint on it. The actual Exhibit E is the entire unit agreement. So the
Okay, so
PowerPoint
E2
only.
is not.
Well, it's part of Exhibit E already.
Okay,
The PowerPoint was only intended to address the specific provisions.
okay. All right. Let's admit those exhibits. Oh,
Any objection?
sorry. Division, do you have questions?
No objection to admitting the exhibits.
Thank you.
All right, with that, Madam Chairman, I'll just reserve my closing marks after the division's statement.
Okay.
Yeah, after a careful review of the exhibits, the division feels comfortable based off of the drainage estimate, well, the actual drainages that have occurred and the 460-foot buffer, that this will protect correlative rights, and that by establishing a unit, it will provide the flexibility necessary for the greatest ultimate recovery, and is very supportive of granting the request. The division would only request that an updated map be submitted. It was mentioned during the presentation in chief that I think it was part of section 29, or all of section 29 is no longer going to be part of the unit. Just for our record keeping, am I mistaken there?
I believe the map shown in the exhibit accurately reflected the northwest of section 29 being removed from our unit boundary. It was simply in the initial unit application for preliminary approval that it was included with the BLM. But what you saw today, it did include the removal of that tract.
Yes, Exhibit D reflects it as it was, it's going to
Perfect.
be approved.
Then we're totally good. And just if there are any changes to the unit boundaries as it goes through the process with the BLM, that we get a notification for our record keeping. But overall, very supportive of the request being granted.
Thank you. Board, any thoughts?
I just want to get one thing clarified. Is the Finley letter of support from May 2023, is it part of one of the exhibits here?
It's part of the record of the pleadings. It's not one of our exhibits, although if it's deemed necessary, we would submit it as an exhibit R as necessary. But it's already part of the pleadings, and it's part of the record.
Okay, I missed it. Okay, thank you.
Mr. McDonald, back to you.
Thank you, Madam Chairman. Again, members of the board, the board has on many occasions recognized the importance of suspending general siting rules and vacating or suspending existing spacing orders for federal exploratory units to allow that flexibility and recognition of the BLM supervision of the unit as well. We believe that Bayless has taken all steps necessary here to meet the regulatory requirements. The two Bayless wells, the rights are recognized there. We're not going to disturb the rights to the production from those two wells. And we would ask, or excuse me, what did I say?
You said the Bayless wells.
I'm sorry, the Finley wells. And we would ask that the board grant the request as submitted. Thank you very much for your time and attention, and again, allowing Mr. Denson to participate virtually.
Thank you. Board, do we need to deliberate, or are we ready to vote? You ready? Could I have a motion?
So I would move that we approve this request for agency action.
Can I have you turn your microphone on, please?
Sure, and clear my throat. I would move that we approve this request for agency action.
And a second?
Second.
All in favor?
Aye.
Any opposed? Thank you. It was unanimous. Mr. McDonald, if you would prepare the order, please.
Certainly, thank you.
Thank you.
Thank you very much.
Thank you.
And with that, I believe we are at the end of our junket here.
Madam Chairman, I move that we adjourn.
All those in favor?
Aye.
Great. We are so adjourned, and we are off the record.